So we got that nice Yak Gotti update and a BRIS update too. Yeah, it didn't go the way that anybody wanted it to go. But something else happened too, and we ain't really gonna like Bruce Harvey too much after this one.
He's never been arraigned on this charge?
He has not.
No, he has not.
All right. Well,
So if we can do it that way,
I mean, is it of the nature that would be right for a plea?
negatory.
All right. Okay.
Well, it would be right, but that's all it would be. We're still, well, we're talking,
All right.
okay?
Well,
He's got multiple cases, Judge. He's got one, like Judge McBurney,
Right.
a more serious case. So I think we're potentially discussing how to resolve that if we can.
So the best way is status quo at this particular
So,
point.
so you're looking for a universal settlement?
Yes.
Okay. All right.
So may we do the arraignment in that fashion?
Sure.
Okay.
Yeah.
And Madam Clerk, may I get the paperwork?
Yes, you may.
Sorry to get you down here for nothing. Of course, I didn't have anything to do with getting. No, I'm talking about the cameraman.
I thought you were talking to me.
No. but it doesn't look like anything's going to happen with Mr. Kendrick's case today.
Trust me, they will come anyway. Let's go.
Are you working with Mr. Harvey?
Yes, sir.
What's your name?
Attorney Nicole Westmoreland.
Okay, Mr. Westmoreland. All right, nice to meet you.
She's the brains and beauty. I'm just the aging boy. It's cold up there kind of guy. You know, I thought this morning that if you're over 70, you should be exempted from coming out in any weather that's below 30 degrees.
Good luck with that one.
I was looking for the exemption.
We were supposed to be taking up Mr. Pearson.
Yes, and we're ready whenever your honor is ready for Mr. Peterson.
And we also brought the two probation revocations, the 12 and 23 already with the court watch.
Okay.
Let them sign that.
Yeah. We'll get Mr. Harvey out. You may, if that's all your business.
Oh, y'all didn't get the next court date. Next court date.
I trust Mr. Harvey. What is it?
It'll be the 5th.
5th February.
Case management.
When's your birthday?
In May.
May?
It's a big one, so
Don't tell me about big ones.
my husband wants to take me somewhere special. I just don't like to fly.
You got to get over that. Judge Downs is down in St. John's right now. The low is 78 and has 81.
Wow.
Pretty nice. And then they're going to New Zealand and Australia in April. 3 weeks. Yeah, she's not letting me dust settle.
Man, places I want to go, I just don't want to get off.
Yeah, my wife doesn't like it either. I mean, she's okay with flying. She just hates flying.
So I got to figure out something.
Well, an Ambien,
I don't even know. What is that? Does that make you sleepy or something?
that puts you out.
Judge Down told me he fly at night. So that.
At night, take an Ambien, a half an Ambien. Yeah, it'll put you out.
So
Sleep.
a few times I have flown 4 hours to the left coast. We've had flights in the evening, so I pretty much was fine. just to come back in the mornings. And the last flight I was on had a little turbulence. Wasn't like what I'm seeing on the news, but I was like, and then it's interesting. One flight I had, I was sitting by someone who, a young man who actually worked on airplanes and stuff, so he was kind of explaining things to me and everything. And I'm like, oh, okay, that's interesting. All right, thank you.
You ever watch air disasters on the Smithsonian Channel?
I stay away from those.
Yeah.
And I don't have to watch that. It's on the news. I don't have to even look at it.
It's pretty interesting.
So, what Bruce Harvey is trying to do, essentially, is this. Let's just plead all of these out and get this man home. The state, y'all gonna want y'all pound of flesh. Y'all basically said universal settlement, which is going to matriculate into universal pleas. If we plead to this, and this, can we get going and stuff like that? But I think the state ultimately wants him to sit in jail for a little bit. I don't believe that the state actually, and this is just a belief of mine, I ain't talked to the state, obviously, or nothing like that, but the way in which they trying to play ball right now, my belief is that they're looking at his pattern of behaviors and going, shoot, he done been in trouble already. So shoot, if we keep him in here a little bit longer, he gonna rack up more charges. And who knows? But the issue that everybody's going to have is, why is an innocent man pleading out? And that's the assumption that you have until they prove it. So to me personally, I'm not Deontay Kendrick, but you got to look at them plea deals. I mean, entertain them, see what they're going to do. They're probably just going to add more probation time and more probation time and more probation time, more than likely. But if it's one of those, and I think what's going to end up happening, them plea deals going to come with some prison time, man, you might as well fight it. I ain't going to hold you. You might as well freaking fight it. It just is what it is at this point in time. Because the longer he stays in jail, unfortunately, as this going to sound, it's going to be better because it's time served already. If he ends up getting out, and I know the family ain't trying to hear this, but if he ends up getting out, say somewhere in August and all this crap, that probation will be done, and then the state is going to have to look actively towards getting him on probation again, and then hoping that he messes up that way. The idea of probation for the state is, hey, we're going to dangle this carrot in front of you, and then when we dangle this carrot in front of you, we think that you're going to bite at it, but you don't know the whole time you've been running. We done caught you in our little trap. And so once we have you, then we got you. We don't have to worry about resources as to fighting you in court because you done already agreed to this in court prior. So since you agreed to this in court prior, we're going to throw you off the rip. That's what that is. They want him to get on probation, hope that he messes up so they can send him to prison and basically belt to ass and give him the max. Will he do that? I don't know. Deontay Kendrick is his own man. But end of the day, I ain't going to hold you, bro. It's looking like they got a fight on their hands, and it's looking like the state is trying to make sure that they get some type of conviction and put on his name so that that way they can get to him. That's the only thing I'm seeing. Whatever the state offers, I don't know, but based on the game they playing, has prison time. But we got some news from Christian Eppinger. Shout out Kat Not Williams for actually dropping this. I was on her live, and then she was reading. She reads far better than me like that. Kat, if you want some money, I got a ton of papers for you to read. Just tell me your price. Please tell me your price. But yeah, Christian Eppinger, man, I ain't gonna lie. Might have misjudged him a little early because check this out. State of Georgia versus Christian Eppinger. Motion to suppress identification evidence comes now. The defendant, through an undersigned counsel and pursuant to the 8th and 14th Amendments to the Constitution of the United States, Article 1, Section 1, Paragraphs 1 and 17 of the Georgia Constitution of 1983, moves this court to suppress as evidence in this case the testimony of any witness as to pretrial identifications of the defendant and to prohibit any in-court identification by witnesses, and in support thereof shows as follows. Defendant anticipates the introduction of eyewitness testimony in this case, including a live and or photographic identification of the defendant. Defendant believes that the identification procedures were so unreliable as to give rise to a substantial likelihood of irreparable misidentification. 1A. Here, the alleged victim stated that he was approached from behind and robbed at gunpoint by two black men in masks. He believed he recognized one perpetrator from a physical disability not possessed by defendant. He did not identify the second perpetrator by name, nor did he provide any physical description of the defendant's face, size, gait, clothing, scar, tattoos, or any other identifying mark, as his estimate of the second perpetrator's size does not fit the physical stature of defendant, nor did alleged victim provide any identifying statement attributable to the second perpetrator believed by authorities to be defendant. A pretrial identification by police via photo lineup was conducted where defendant was identified as the perpetrator of said offense. Defendant was not represented by counsel at the time of the photo lineup, and the procedures used by the police and state official in conducting the same were designed to focus upon defendant. Here, the alleged victim did not identify the named perpetrator during the first photo lineup conducted. The defendant was identified during a second lineup where the officer conducting the lineup pulled defendant's photo from the third position in a stack of photos consistent of lineup and placed it on top of the stack in the presence of the alleged victim, upon which the alleged victim selected defendant's photo. It is, of course, well established that there is already a great potential for misidentification when a witness identifies a stranger based upon a single brief observation in a stressful situation. United States v. Russell. The innumerable dangers inherent in such identifications, which have led to a high incidence of miscarriage of justice, were described by the United States Supreme Court, United States versus Wade. As the court observed there, the lack of reliability of such evidence is well documented. The Due Process Clause of the 14th Amendment protects an accused against the admission of unreliable identification evidence. Manson versus Braithwaite. We ain't finna do all this. Because the intrinsic unreliability of witnesses' identifications is so often compounded with the distorting effects of the natural suggestion to the witnesses that the person on trial is the guilty one. It is no exaggeration to venture that the influence of improper suggestion upon identifying witnesses probably accounts for more miscarriages of justice than any other single factor. Perhaps it is responsible for more such errors that all other factors combined, such evidence must be excluded, whereas here the totality of the circumstances indicate that the entire identification process was unreliable and thus resulted in a substantial likelihood of misidentification. Here, under the totality of circumstances, there exists a very substantial likelihood of irreparable misidentification because the photographic identification procedure here was so impressively suggestive so impermissibly suggestive, as the alleged victim did not have a good opportunity or long time to view the perpetrators, as the robbery only lasted seconds. In addition, the perpetrators were wearing face coverings at the time of the robbery, could only have possessed a low degree of attention to the perpetrator's identity, and the presence of the weapons and the assailant's various instructions and demands surely affected the alleged victim's degree of attention, did not provide an accurate description of the criminal prior to the suggestive lineup, as the physical description given does not match defendant, demonstrated a degree of certainty in the identification of defendants as a perpetrator only after the suggestive act of placing defendant's photo on top of the pile of photos by the officer in the presence of the alleged victim, and only identified the defendant during the suggestive lineup performed 8 days after the crime, after providing no other piece of identifying information. Defendant in 8 days based his identification upon inducement by the conduct of the lineup and not upon observations at the time of the assault at all. Because of the pretrial identification was obtained by law enforcement authorities in violation of the defendant's constitutional rights, the prosecution can elicit an in-court identification only by showing by clear in convincing evidence that any in-court identification will rest upon a source independent of the illegal pretrial identification procedures. The defendant submits that the prosecution cannot make the requisite showing in this case. Our appellate courts have disapproved of such practices as one person shows up, confirmation of selection from photo spreads, and one person in court identification. Barring suppression, the defendant moves in limine to prevent any testimony by law enforcement agents regarding the alleged identification. In totality, the pretrial identification procedures used by police officials were unduly suggestive, and therefore, any evidence as to pretrial identifications or in-court identifications will be tainted. Wherefore, the defendant requests this court to order pretrial evidentiary hearing on the matters set forth above, and further requests that any such illegal identification be suppressed from the trial of this matter this 6th day of January 2025. Eric R. Johnson, and we'll leave it at that. Yeah, I certified this day, served a copy within the foregoing motion, suppress identification upon opposing counsel by deposing the true copy of the same, United States Mail, proper postage paid, address following, Fonnie Willis, Esquire, District Attorney Office of the Fulton County District Attorney. So basically showing that she got it. I think the best way that I can paint this illustration for y'all is this. Remember when you were a kid, right? And the way in which you would tell if you had a sibling to try to get them on your side to convince your parents that you didn't do what you were accused of doing. You say, remember when I was with you yesterday and we were eating candy? And then your sibling has to say, yeah, it's all coerced. So that's all coercion, because for him to have taken the photo from the third and then placed it on top, that is prejudice. That's not good police work. That's 100% being biased towards whomever it is in which you are. I thought the police and their handling and stuff like that, as far as justice, was supposed to specifically set this one out as far as they pretenses and just go, hey, here you go, here you go, here you go, here you go. And they do have a point. Bro, if I approached you and the only person that you can really identify was somebody who probably had a disability within walking or something like that, bruh, it ain't me. And he already said, description-wise, height-wise, I think Christian Eppinger's like 6'4" or something like that. So you have that existing. And then on top of that, not only do you have that existing, you have the fact of the matter of, if we all masked up and all that stuff, how the hell are you going to pick somebody out? Just being fair. Like, how are you going to pick me out of this lineup and I got a mask on and I'm covered up in all this crap? Now, Christian Eppinger would have said, stick up, give it up, and all this stuff and everything in his regular voice. I'm not saying that he did, which they're not alleged. Then yeah, you can have him speak and then go, yep, that's him, because I know that voice. But other than that, I don't see how they make the inference of that. But it's all going to boil down to jury selection. It just is. It's going to boil down to people who actually will say that the individuals are innocent. There are preconceived notions. The one time in which I had jury selection, I ain't gonna lie. When they told me the charges, and this was, I can't say the word, but this was a dude alleged to have slept with a younger lady, and what they were saying and all this stuff and everything like that, I'm like, bruh, that man guilty. Ultimately, I got booted off because I told the judge, I don't trust the police. I don't care. I assume all police officers are liars. I don't take them at their word. And then the judge was like, so you telling me if an officer came, you wouldn't take him at his word? I said, hell no. So the judge told me, yeah, you can go. It is what it is. But back to it, man. So they just had to make the case, unfortunately. And I don't think they can. So Christian Eppinger's attorney, like, that, it shouldn't even come in. I'd be curious to see, because I think ultimately they will, because they're probably going to add or bring in extra factors and all this crap and talk about other stuff that was left out in the motion to basically get rid of that and everything. And that's where we're going to see the person still make the freaking appearance to the courtroom. But the cross just has to be amazing. That's all. The cross just has to basically do just that. Now, some of y'all say, well, why would he file the motion knowing that the person's going to come in? Because you miss 100% of the shots that you don't take. So with that being said, I think the person comes in, and I think the cross just has to be electrified, because if they can do that, you might be able to paint him as a sympathetic figure. If they are able to make Christian Eppinger out to be that, then so be it. But I will say this, because it just is what it is. We still just got to wait for all the facts. I don't care if you believe they did it, whether they didn't do it or anything like that. Please let your judgment be out there, but allow it to be able to be revised. Just know what we think we know, we don't know. What we do know, we might not know enough. So that's just what it is. As far as how everything else is going in the trial, we're going to see. It's supposed to last 3 freaking months. You know we're going to break it all down here. Unfortunately, it just is what it is. The algorithms is like, we want to push out that YSL stuff, Ceddy Nash. We don't care about none of that other stuff you're talking about. So you're going to see a couple of more YSL videos, but I don't care. We still going strong with everything else. Yeah, I've been in that gym. We still going to go strong with everything else that we've been pushing out. So if you can, hit the like button, run this psych up. Check out the previous video, because I think we were able to kind of nip it in the bud before we even got it there. Or maybe we didn't. But I'll catch you on the next one. Yeah, man, we just hit 200K. We on our way to 300, man. Subscribe today so you can find out how you can win an Xbox or a PlayStation, man. The details are on the way. This is how you know somebody is literally going to be in the drawing. Robin Minter, check him out, man. All we do is go down and we look and we see his subscriptions. Who does he have? That's Ceddy Nash right here. What also happens, take that off, top commenter. That right here, public subscriber. So that's what you got to do, and make sure you share each video, and then you'll be entered to win. Shout out to Mike. Good luck. Subscribe, turn that bell, stay notified, and share to keep your people aware. I'll catch you on the next one.